Hi, it's Phil Anderson, General Manager, Policy, Advocacy and Standards at the FAAA. In this video, I'll provide you with more detailed information about the introduction of the website disclosure information option for providing your FSG, and the main aspects you need to be aware of when making website disclosure. This change implements Recommendation 10 of the QAR. The purpose of this change is to provide a cost-effective and flexible alternative for you to provide the information currently required in the FSG. While this change commenced on 10 July this year, there are certain requirements about how the information is presented on your website that you need to understand before you start relying on website disclosure. Critically, if you want to rely on the website disclosure option for providing your FSG information to clients, you must obtain the approval of your licensee. So please speak with your licensee. ASIC RG 175 provides guidance on your current obligations in relation to FSGs. We anticipate ASIC will provide updated guidance to incorporate the website disclosure information requirements, and we will keep you updated on the timing of this guidance when it is known. In the meantime, we hope this video helps you to understand your obligations. As with most changes in the law, we have a new term to learn. Website disclosure information is the legal term given to the FSG information when you post it on your website. Under these changes, you can now choose whether to continue giving a printed version or emailing a PDF version of the FSG to your client, or alternatively, make the FSG information available on your website as website disclosure information. You don't need to do both. If you choose to post the information on your website, the website disclosure information must include the same statements and information that is currently required in an FSG. If the FSG requirements are subject to any modifications or exclusions, those modified FSG requirements also apply to website disclosure information. As with an FSG, it is imperative that your website disclosure information is complete, accurate and up to date. And you continue to take reasonable steps to ensure that the disclosure information is complete, accurate and up to date. Everything you are currently required to include in your FSG, you can now choose to post on your website instead. For example, your name and contact details and those of your licensee. Your authorised representative number if you currently need to provide it in your FSG. Lack of independence statement if that is relevant to you. The purpose of the website disclosure information, as well as different disclosure information such as SOAs or PDSs as currently required. Information about your services, your remuneration and benefits in relation to your advice. Your relationships and associations. Dispute resolution information. And importantly, if you provide further market-related advice or advice that does not recommend the purchase or sale of products to your clients, your website disclosure information must inform your client of their right to request a record of advice. Just like your FSG, you must ensure your website disclosure information is up to date. This requires any changes to your website information to be authorised by your AFSL licensee, and the website information must specify the day on which it was prepared or last updated. If the alteration is a material alteration, the website must clearly show the date on which that alteration was made. This ensures that important changes are recorded. Website disclosure information can also take any form. It could be written information, graphic information on a web page, be in a portable downloadable document file or files like PDFs, for example, or be made available in other forms or formats. There is flexibility on where the website disclosure information can appear on your website. It is not necessary for the information to be co-located on your website. It can be posted across different locations or part of your website, but it must be freely available and readily accessible to the public on your website. It should not be password protected or accessible only to persons who have created an account or have a paid subscription. Generally, if you provide advice to a retail client, you're currently required to give a client an FSG, supplementary FSG or updated FSG before you provide advice. Just as with your current FSG obligations, you are not required to make website disclosure information available if your client is not a retail client. You have already given your client an FSG and the information in the FSG has not changed. You give the client a PDS and a statement that together contain all the information that FSG would be required to contain. Your advice relates to a basic banking deposit product. These same points will apply, and you must make sure that this information is available to your clients on your website. Remember, you can choose to continue to give your client an FSG or post the same information on your website. You don't need to do both. Currently, you must give your client an FSG. If you choose to rely on website disclosure, the law says you must make available this information before you provide your advice. We've received a few inquiries about what make available means in practice. The law says the information should be published, free and readily accessible on your website. Some have suggested it may mean you should tell your client that the information is there, that is available on your website, and should suggest they read the information before making the informed decision about using your services. While this isn't clearly articulated in the law, this approach may be in line with your current obligation to give your client the FSG. At this stage, we suggest seeking clarity from your licensee on their expectations on what you need to do when it comes to make available. You must keep records of your website disclosure information to demonstrate compliance with your obligations. We expect this will be in line with your current FSG record keeping obligations, and that ASIC will include this in updated guidance. The FSG disclosure regime attracts significant penalties for non-compliance, including imprisonment for up to 15 years for some breaches. Yes, quite remarkable, isn't it? These same penalties and sanctions will continue to apply to both the FSG disclosure obligations and the new website disclosure information option. Some of these penalties relate to the distribution of the information without licensee approval. This includes any updates or alterations to the FSG or website disclosure information. The disclosure of defective information. Notifying the licensee of defective information. Correcting defective information. Not providing a FSG or making website disclosure information when required. The FSG or website information is not up to date. The information does not show the date it was prepared or last updated. Making the information available recklessly as to whether a person will or may rely on this information. In conclusion, we hope this guidance video has been helpful. Please email us at policy@faaaa.au if you have any questions. Thank you for listening.